Hello everyone, I'm Audra Doyle and I'm the owner and attorney of Doyle Law here in Atlanta, Georgia. Today we're going to talk about medicals. Many of my clients, actually anyone that's filing an adjustment of status application, needs to submit a medical to immigration. But there are rules to follow and I'm going to share with you the rules today and what happens next when we're filing your case. Medicals are required for each adjustment application, plus if you're overseas, you need to submit one as well. There are 3 times in your case where we are permitted to submit a medical. The first time that we get a chance is at the beginning of the case when we're ready to file the papers. The second time we get a chance is if we wait until immigration asks us for the medical. And it's called a request for evidence. They'll mail us a letter. They'll say, please send us the medical. We turn the medical in. The third time that we can turn in a medical is at the interview. And they won't say, bring the medical, but we know we didn't turn it in at the beginning of the case. They haven't gotten it yet. We know that we need to bring it to the interview. There are some factors that make it a little tricky that I want to share with you. And with each of my clients, we talk together and decide what to do. If you want to turn in your medical at the beginning of the case, you need to keep in mind that the medical will expire in 60 days after that doctor signs it. So what needs to happen is it needs to be signed and submitted to immigration within 60 days of the civil surgeon signing the forms. If you get the medical 3 months before we submit the forms, you have to do it all over. The next thing to know is that a medical is only good for 2 years. So if your case drags on for more than 2 years, you will have to get another one done. And that time frame does affect when I suggest we should get the medical done. If I think the case is going to take longer than 2 years, I will say, don't do it at the beginning of the case. Wait until the end. We'll turn it in then. And that way I'm saving my clients money. Now, immigration, they know the rules, but they want to give us reminders. And a few years ago, they would send us a happy yellow letter that said courtesy letter, and it would remind us that we're going to need to send in the medical. Nowadays, they send us a not so happy purple letter, and it says I-693 deficiency notice. It says your case is deficient. It's the same thing as a courtesy letter. It just says, we see that you didn't submit your medical, and it says you will be required to submit the medical. That's all this letter says. So if you get a letter that says deficiency on your case and you haven't submitted your medical yet, don't be afraid. We know that we're going to have to turn in the medical, and actually, this is not a request for evidence. I am not permitted to mail my medical back with this document. I have to wait until I'm asked or we take it to the interview. That's the time to turn it in. So your case is fine when we submit the medical at one of those points. And I will help you once again decide when to do it. The last thing to know is, where do you find your doctor? There's a website called myUSCIS/Find a Doctor. You can Google Find a Doctor, USCIS, and find the list, or look on your welcome sheet from our firm, and we also have the link right there for you. I hope this information has been helpful to you, and if you have questions about your medical, or if you receive a scary purple letter, don't be afraid. Just let us know. I also get the copies, but we know what to do, and there's nothing wrong with your case. Hope everyone has a great day. Contact us for help with your immigration matters.